with regard to bond setting, certainly starts with the premise that everyone is entitled to a bond, a penal bond, or some other type of bond, unless they present an unreasonable danger to themselves or the community, or unless they present a flight risk. In considering those factors under 17-15-30, the court is to consider, among things important to me here today, the financial resources, the character and mental condition of the accused, any charges pending at the time the release is requested, all incident reports generated as a result of an offense or charge, and that the arresting law enforcement agency is to provide the court such information. The defense has filed a memorandum in support of bail in which they acknowledged and indicated that Mr. Murdaugh is a recovering opioid addict of approximately 20 years. And since then, he's spent millions of dollars supporting this insidious addiction. He goes on to contend that following the death or murder of his wife and son on June 7, 2021, his opioid addiction spiraled out of control and he became reckless in his financial dealings, at which time the firm became suspicious about missing money. He then was moved to a detox facility in Section 6. After attempting suicide on September 3rd, then indicating that he voluntarily surrendered himself to law enforcement after coming back from Florida after there being an indication of charges against him. The state suggests that a $200,000 surety bond will be sufficient to guarantee all the protections required by the law. The defense seeks a personal recognizance bond. I am concerned, however, with the safety issues that are present, not only as to Mr. Murdaugh, but the community. And perhaps 78% of the cases I deal with in criminal court involve someone with some type of drug problem, drug addiction that results in serious criminal consequences. Rarely 2 or 3 weeks go by without me having the occasion to sentence someone to prison for 30 years to life for murder and other offenses committed while under the influence of drugs. Here the defense suggests that Mr. Murdaugh has an insidious addiction that's lasted over 20 years, during which time he's achieved high accolades under the law. He's been placed in significant positions of trust, and he now stands accused of stealing millions of dollars through breaching trust, deception, and other unequal wounds. There is no amount of bond that the court can set that would safely provide protection to Mr. Murdaugh, to the community, and satisfy the conditions of the statute in my mind. With regard to the character and mental condition of Mr. Murdaugh, who's admittedly attempted suicide or engaged in a conspiracy to commit murder through a co-defendant. At least that's what's alleged, with a great number of pending investigations, matters that law enforcement has to some degree disclosed and some degree not disclosed. There's no way that this court can set a bond at this time. I am therefore denying bond at this time, and I'm requiring Mr. Murdaugh to undergo a psychiatric evaluation to be submitted to the court for further consideration at a later date. And that's the order of the court.
Thank you, Judge.
Your Honor, when you say psychiatric evaluation, you're having you're going to sign an order to determine whether or not he's competent to stand trial?
No, sir. He's not competent to stand trial, but a report of his mental and psychiatric condition. I'm not relying upon representation regarding treatment from out-of-state agencies, reports of which I have not seen or received, but only representation by counsel. I'm not satisfied as to his mental condition such that I would consider that a factor favoring granting bond.
So I guess I'm asking for guidance from the court. What is it that you would like from us for you to examine?
His psychiatric condition, his mental condition.
From the treatment facility?
Whomever that can provide it. Can be a psychiatrist, can be a medical doctor with sufficient credentials. That would be for the parties to determine.
And once we provide that, you then at that point consider bond?
At that point, at whatever point I might reconsider bond, it would be based on additional information that exists at that time, including anything further regarding further investigations.
Yes, sir.
Thank you, Your Honor. Your Honor, are you ordering a psychiatric examination, or you just want additional information?
I'm ordering that the defense produce a psychiatric evaluation.
All right.
I'm so sorry.